Well, hello, Lyric Armstrong, your real estate agent and advocate. We are here. We're still at Judge Simpson's court. His landlord tenant docket is popping. So come on in. Let's get into court. And before we do, let's take care of a little bit of housekeeping. Sweep up a little bit, clean up a little here and there, wash those dishes by sharing, and subscribing. Oh, that's such light work. I love it. So just make sure you like, share, and subscribe. Let's get into court here at Judge Simpson. Hey, Judge, we are ready. We are ready for court. We're going to take care of our business too. We're going to go ahead and like the video. All right, Judge Simpson. Let's see. What is... Start right here. Here we go.
Amazing how that works.
And quick reminder, we keep it loud, so unplug or turn that volume down just in case. Don't want you to wreck your hearing.
All right. Court calls the case of Arbor 1 versus Melissa Lee.
Cheryl Walkoff on behalf of the plaintiff.
Good morning, Your Honor.
Hello, Miss Lee.
All right, she's off. She's on her camera on.
Okay. So we had some repair issues.
Yes.
She was going to put rent in escrow. She's done that. And where are we with the repair issues?
Your Honor, Amy too is not available today, so I couldn't have her log on. She was out of town. I could not reach her. What I do know, what was submitted to me from Amy before she left, was that Ms. Lee indicated she did want to vacate the premises. My first question would be, is that correct, Ms. Lee?
Yes. I didn't submit more pictures to you, Ms. Luckoff, but the mold and mildew is coming back, and it looks as if another hole is breaking through. And I've obtained a new rental, so I would like to vacate. I mean, it's just too disruptive. They've been in the apartment 5 or 6 times to repair this over the last year and a half. The mold and mildew is affecting my son, who has asthma and allergies. He's got daily headaches. I mean, it's just too much.
You know, there are a lot of times that tenants will make complaints that are really, I think, inconsequential and of no real issue. I really give credence to what she's saying. I think that this is highly pertinent information, and mold and mildew can be extremely toxic for those who have asthma and allergies, especially, but for all of us in general. I hate mold and mildew, and I don't understand why 5 times. Sounds like all we're doing is like cleaning the area and moving on. But if there's a collection of mildew in a space, it lets you know that there's not proper ventilation. So you need to probably up your particular remedy, because you want to make preventive measures too, not just responsive measures. Because this tenant is complaining, but the next tenant is going to have the same complaint, and you're on notice and on record in court letting you know that this is something that is a problem with this particular unit. You need to really try to invest in either a high power fan for that particular area that's, helping to keep the area dry, or you might have to go the extensive route of inputting a window so that the steam or whatever this moisture is can escape. But definitely go through the proper measures and talk to your construction general contractor so that you can find out how to best resolve this issue on a long-term basis versus having to usually come in, because 5 times within a year and a half to correct the same issue in the same place really is extensive in my personal opinion.
I mean, Your Honor, it's plaintiff's position that we've gone in and repaired each time. I'm not disputing that this has been an ongoing problem. We wouldn't be willing to waive any rent. So I'd either ask to set it for next week so Amy can come in and update, or alternatively.
So the tenant would behoove to have an attorney. Doesn't sound like she has a representative of her own, whether it's legal aid or otherwise. But the attorney can make an argument that you have unsafe living quarters, so you need to waive a portion of the rent. Otherwise, this can be but to me, I would want my attorney to argue, no, you don't get rent because the space is not livable. I mean, you have to prove that you're out of the place and whatever have you. But, if the conditions are as she professes, And that the landlord has accepted that there's actually been mildew and mold visible and present. It's not as if she's made it up. She didn't put it there. It's coming upon its own volition based upon lack of proper ventilation. Then you don't have a dispute on that matter. So I would definitely, in this instance, this is why I said always get an attorney. Attorneys get attorneys. Everybody should get an attorney. No matter how much having your own representative to advocate and to fight on your behalf is much more advantageous for you than you trying to do it for yourself. And so it would have been to my liking, I would have had my own attorney to argue, no, we definitely dispute that, all rent is due.
We could convert this to a termination, select a move out date, and the parties don't waive any claims, however the court wants to proceed.
Ms. Lee, when does your lease expire?
My lease expires November 30th. So I would be vacating 2 months short of the end of my lease.
Okay. And how much is plaintiff at this point claiming is owed?
$4,484.
$4,484.
Oh, that must include September, which I did put in escrow.
Right. That would include, because that has not been paid to the landlord, so that would include in that total.
Right, Your Honor.
I get that. Okay. So we're at about the $3,000 figure. And so, Ms. Luckoff, you would not be in a position at this point to be able to agree to a vacate date. Is that the deal? Or?
I would prefer if we can just set this off 1 week, but if the court.
Okay.
Thank you.
All right. Why don't I do that? Okay, Ms. Lee, let's see if we can get something worked out on this.
Okay.
I think it would behoove everyone. So I'll adjourn this matter to
September 15th at 11 a.m.
September 15th, 2023 at 11 a.m.
Thank you.
All right.
Okay.
All right, Ms. Lee, thank you. That's me. Court does call the case of Arbor 1 versus Akiba Tucker.
Cheryl Luckoff on behalf of the plaintiff.
Hello, Judge. Good morning.
Okay, but the plaintiff's not in town for all
Are you
these
able to hear me?
Yes, I am, ma'am. Okay, where are we on this case?
Are you asking me? I'm sorry.
I mean,
Yes.
Go ahead.
Okay, so so I moved in April. Since I moved in, I have most of my repairs have not been done. I had a gas leak that they did not fix for 4 months that caused my son to get very ill. My floor just fell through because they did not fix the toilet that I've been complaining about since I moved in. It took them 2 months to fix my porch. I still don't have electricity in some parts of my house. Didn't have it in my bathroom for about 2 months. When I asked them if I could have somebody come in and just build them, they told me no. They told me my problems were not severe enough at the moment. They were not an emergency. My son's been sick. I do not want to live there anymore. They will not do what they say they're going to do. I have all the proof to send to the court. I have no problem doing that, but it is a health hazard. They told me that the gas leak was not serious. DTE told me it was. I think that this is very wrong.
Okay, so it's a song. I ain't saying that gold digger or she a gold digger. I feel like we need a song saying, I'm not saying you a slumlord, but this is case number 2. That is saying that the conditions of the property are lacking substantially. She has a floor that's falling in. You have a gas leak. I would be reporting you. Sorry, you would hate me because I'd be reporting you. You're gonna have so many health code violations on your hands.
You're right. Just the first, I'm just looking to see if I missed something. I don't recall ever being, because you know what happened? We entered a judgment. Okay, this was initially, as you know, initially with Judge Barr. She did not appear. I took a judgment.
Yes, I did.
And then he said to me,
Ma'am, do not interrupt, please. Go ahead, Ms. Luckoff.
thank you. Judge Barr did say if she appeared later, that he would schedule it for a second hearing. She must have appeared because I saw this on the docket. So
Got
this is all new to me.
All right, ma'am, are you going to file a written answer to the complaint?
Yeah, actually, I'm sure. I'm trying to find out what I'm supposed to do. I haven't been able to get legal aid. I've tried. So at this point, I want to move, but I don't want an eviction on my record. I want my security deposit, and I need to know how I need to go forward to make this happen. Because
Okay, so she doesn't qualify according based on what she's saying, she's not qualifying probably because of her income for the particular legal aid representation. However, I don't know a courthouse that doesn't have self-help. So you should be able to go to self-help desk and they won't give you legal advice, right? But, if you want to do an answer, they'll give you a judicial form for an answer. And you put those items in there. She really needs an attorney because she wants legal advice. This is what she's asking for, and everyone's probably trying to skirt around giving her actual legal advice because they don't have representation of her. She doesn't follow.
I have proof of everything.
Okay, so she wants trial. Okay, got it.
Defendant to file a written answer within 7 days. I am, since this is being adjourned out. What is the monthly rent?
Your Honor, $1,350.
1350?
Yes.
All right. Yeah. Okay.
I'm gonna calculate.
Right. And it's going to be times, today's the 8th. So it's going to be just times 22. All right. I'm going to order escrow be paid for September in the amount of what? $990. In the amount of $990. And then if this matter proceeds into October, you have to pay the $1,350 per month beginning October 1st. Do you understand that, ma'am?
I do. But if I want to move, what is my process? What do I have to do?
All right, ma'am. I've got to get to what all of the issues are in the case. That's why I need a written answer within 7 days. I'm ordering escrow in the amount of $990. That is for the month of September. That's a prorated amount that needs to be paid to the court. So you need to pay that within 7 days. That needs to be paid in cash at the court. If it proceeds into October, you need to pay the $1,350 beginning October 1. The resolution of those funds, I will decide at the end of the case. Understood?
Okay, thank you.
And so since that's due within 7 days, I will adjourn this to next week. To the 15th, 9/15, 2023 at 11 a.m. And ma'am, when you do your answer, you need to send a copy to plaintiff's attorney, Ms. Luckoff.
Oh, the answer goes to her.
Well, you need to send one to the court and also a copy to her, to Ms. Luckoff.
Okay.
All right. Thank you.
Thank you. Appreciate it.
Woo, somebody tell Madam Tucker, go find your self-help desk. Go down to the courthouse and find your self-help desk. Because your answer, go ahead and get your judicial form for an answer. File it with the court, get a waiver of attorney court fees if you can't. Well, she probably doesn't qualify for this, but whatever. If she qualifies for the waiver, then let her go ahead and file that too. But file that answer with the court and make copies and send it off to Attorney Lockoff today. Don't wait. I just have a feeling she's going to wait till the 15th and turn everything in then. We have a court hearing on the 15th. The $990. Okay, so the $990 was the prorated amount, so that's why it's different from the $1,350.
Court does call the case of Six Trails versus Charles Butler.
Carol Walkup on behalf of the plaintiff.
Good morning, Your Honor. Seth Older on behalf of the defendant. Good to see you again.
Good seeing you.
I think you said a different landlord this time, I think.
Thank you.
Okay, where are we on this case?
Well, Your Honor, the parties have agreed to the entry of a dismissal. The defendant has vacated the premises.
Oh, yay.
So you're moving to dismiss?
Moving to dismiss. There's actually a stipulated order was sent.
was there?
Yes.
Ah, you
After
have
your
it.
cutoff, but
Got it.
should be there.
Awesome.
Okay, it is here. Okay. Case is dismissed. Thank you,
Your
folks.
Honor.
Thank you, Your Honor. Take care.
So Attorney Seth is happy as pie. Yes, Honor. Yeah, sign that. Thank you so much. Moving right on.
Let's call the case. Six Trails versus Brandon Lawrence.
Carol Walkup on behalf of the plaintiff.
No, I think that's the same place. Six
And
Trails.
this tenant is not checked in. Would you like to take a default?
Yes,
Oh,
Your Honor.
man.
This is a termination, but I can be sworn in. I don't have much to say other than it's a termination.
Okay.
Do you want
All
to?
right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
So remember, the attorneys are officers of the court. But if the attorney has testified to any facts or any, elements of the case, they too have to be sworn in. So that's what's happening here.
Your Honor,
All right, go ahead.
moves for a possession judgment in this matter. This is a termination of tenancy, and the defendant is still in possession of the premises, as far as I am aware.
Judgment to the plaintiff. That's by default for possession. No redemption amount. Writ to issue 10 days. All right.
Thank you very much. Okay, that was too easy, right?
That is way too easy, it seems. All right. You have a great weekend.
I don't know. You can check your client out. Send
Court's in
them.
recess.
You need to send that client a contractor so they can get their stuff done on time. It probably would benefit having a on-call maintenance worker to just come and maintain the property. Ooh. But anyway, what happened? So we can get back to court. We got some people waiting. Oh, Hitchcock. Is Alfred Hitchcock your relative? He probably gets it all his whole life. But it would be cool if he is his relative. He has the same nose. Hey, Hitchcock. But didn't see Hitchcock. We'll figure out if he's related. Because let's see here. Everybody's getting into the waiting space.
When you say a payment,
All right, Judge is coming back in. Wait, I missed
that's by
him.
default for possession.
Hold
That
on.
if the defendant,
Whole truth and nothing but.
okay,
Okay, all right, he's coming in.
Your Honor,
Court does call the case. Is that it for you or no? Yeah, it is. All right. Have a great day.
you as well.
Okay, here
Arbor
we go.
Knoll versus Jessica Miller.
I know that case.
Arbor Knoll. Mr. Hitchcock, I think we got your cases up.
So get off the phone.
I'm sorry, Your Honor. Good morning.
Good morning. I called Arbor Knoll versus Jessica Miller,
Okay,
and Miss Miller is not present. Would you like to take the default?
yes, I respectfully request the court enter default against
I
Ms.
need you to
Miller, Your
raise your
Honor.
right hand to be sworn, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
All right, go ahead.
Your Honor, there's currently rent to retain possession in the amount of $2,177.76, costs in the amount of $163, for a total amount due and owing in the amount of $2,340.76. Plaintiff respectfully requests that this court enter a default judgment against the defendant, that if the defendant does not pay that amount or move out on or before September 18th, 2023, that the writ may issue, Your Honor.
Judgment to the plaintiff. That's by default for possession, redemption amount in the amount requested, writ issue in 10 days. Augusta Woods versus Kyla Coleman.
Good morning, Your Honor.
Good morning, Your Honor.
Thanks.
Clifton Hitchcock, Swiss Jack Levine on behalf of the plaintiff.
All right. Miss Coleman?
Yes, sir.
All right. Counsel, how much is owing on this account?
Your Honor, total amount due and owing is $1,838.64.
That includes your costs?
That includes costs of $160, Your Honor. Yes.
All right. Miss Coleman,
Yes, sir.
how are you intending on getting that paid?
I thought I was be able to make a payment today, but I'm not able to, so I'll be able to make a payment in a couple weeks. This house is up for sale. I just found out Friday that my the lady put a bid in, she backed out, so I'm kind of back to square one with this house. So, but I do plan on making a payment hopefully in a couple weeks here. I know I will in a couple weeks.
Is she a real estate agent? Sounds like she's saying when escrow closes on one of her deals, she'll have the funds. I know those struggles. That's my life. That's part of it anyway. Comes from escrow.
When you say a payment, paying off
Yeah.
that full amount or?
Not the whole full amount, but I will be paying something towards this amount, definitely.
Only at 18.
Not the whole full amount, but I will be paying something towards this amount, definitely.
It's
all
only. I don't understand.
Court is going to find that, given that there's no tribal issue and after hearing on the matter, I'm going to enter a default. I'm going to enter a judgment in plaintiff's
Favor.
favor for a total amount of $1,838.64. Ma'am, so the writ date or the date of move out would be the 18th. When you say a couple weeks, when were you going to be able to make a payment or try to get this paid off? I don't mind giving you more time.
In 2 weeks, that's my next pay. On the 22nd is my next pay.
22nd.
Yes,
All
sir.
right. So I'm going to enter that judgment with a writ to issue. I'm going to give her an additional week, the 25th, see if she can work out whatever she's going to work out.
Okay, thank you. 9/25.
Thank you.
Okay, so she's gonna get the judgment against her, so that's filing against her. The tribal issue concern, which just means that there's no issue for court. There's no argument, there's no defense, you concede, so consequently, it's just a matter of getting payment in. Once it's paid, it's paid. If she pays all of it, then she won't have to vacate, unless she already has. But if she doesn't pay all of it, then the writ that he's talking about is a writ of eviction. Okay, so that's 10 days. For this court, it's 10 days after the judgment. Judgment is on the 8th, 10 days is the 18th. He's giving her to the 25th because she's saying it's going to take her 14 days to the 22nd to get the funds to make any type of payment, but not all of it. So she's still going to have a writ of eviction because unless she can work something out with the landlords, because she's not paying all of it.
Thank you. Have a good day.
You do the same.
Thank you.
Augusta Woods versus Jada Johnson.
Good morning.
Yes, Your Honor.
This is Leela
Clifton
Johnson.
Hitchcock. Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff, Your Honor.
Cleanup goes first.
Good morning.
Is it Jada Johnson and Leela Johnson? And your name, ma'am?
Leela Johnson.
Leela. Okay, I mispronounced it. I'm sorry.
That's okay.
All right. Okay. How much is owing on this account?
Your Honor, total amount due and owing is $1,803.92, and that's inclusive of costs.
I done my paperwork. I had to have a separate ledger. My first and second ledger wasn't correct. I got a ledger last night that's still not correct. I have a balance of $1,758.92, including court costs. They have October's rent on there, and October isn't even here yet. They have October's first month and late fee on there, and it's not even October yet. So they keep giving me the wrong amount on my ledger.
To my knowledge, Your Honor, this amount stated by me today does not include October. It's through September.
Okay, I have the ledger that has October date on it.
Okay, but
So if I subtract
ma'am,
October, yes.
what is the amount that's on that ledger?
The ledger, I would have to take it off. Let's see. The ledger that they emailed me yesterday had 16. Shoot. Let me see. Let me go to my email. The ledger that they sent me yesterday has. Come on. Open.
I think you're looking for the 1643.92. That's the rent to retain possession before we
Yep,
had.
yep, 1643. Yep, 1643.92. And on this ledger at the bottom, do you see where it has October payment on there? 10/5/23.
I do not have that, no.
Okay, it's on the one that she emailed me last night.
Well,
So
ma'am, hold on a moment.
Okay.
Last week, when you appeared before Judge Barr,
yes,
there was a total amount, and it would have gone up because there would have been some fees added. There was $1,758.92, including costs.
yes.
My understanding was there was no dispute as to that amount. And then I have a note here that says that defendant says she can pay on the 13th of September.
Yes. Okay. So with that being said, the 1758.92, my payment after surgery, I got my medical payment. It will be ready on September 27th. If I can get to the 27th to pay the 1758.92, I could do that.
Well, except ma'am, from that time to this time, there's been late fees added. So the 1803 is the 1803, and what was the cent on that, counsel?
92 cents, Your Honor.
92 cents.
Okay.
That's the amount that's owed now.
Okay. Because the late fees and added in the court cost. That's fine. Yes.
Right.
Okay.
So
Okay.
now, what date can you get this paid?
September 27th.
Okay. So here's what I'm going to do. I'm finding no tribal issue after hearing on this case. I'm going to grant a judgment for possession. Redemption amount $1,803.92. And that, with the writ to issue, you're saying on the 27th?
Yes. September.
What happened to the 13th?
Well, my payments, I had foot surgery and my medical payments was supposed to be, I thought I calculated incorrectly.
Okay. All right, counsel, over the objection of plaintiff, I'm gonna, with the writ to issue the 27th.
Okay.
All right, I've given you your day.
So I'm concerned about the dates because say you get your payment on the 27th. If the writ is to be issued on the 27th, I believe you have to, I believe then if it's issued on the 27th, then it's the 28th that they will execute it the next day. And, you know, say you put the payment in on the 27th, will you have enough time to, you know, to suspend it? So anyway, judgment for possession and the redemption date is what he's giving. So redemption amount is the 1803.92, which means that if you pay that amount, then you redeem possession. You get to stay in the property. That's the definition of the words of what he's stating in his judgment.
Date, their number,
Okay.
and see if we can get it paid.
Okay,
Thank you.
thank you. Thank you.
He seems,
Court calls case, Augusta.
he gives me like he's aggravated that it wasn't done on the 13th, but he's going ahead and giving her the extra time. And he's like, okay, that's it.
Woods versus Rachel Lindberg
So hopefully she,
and William Lindberg.
Your Honor,
Mhm.
Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff.
I do not have these tenants checked.
They are not checked in. Has he been sworn?
Yes.
All right, so you may proceed, counsel.
Your Honor, there's currently rent to retain possession in the amount of $1,783.66, cost in the amount of $160 for a total amount due and owing in the amount of $1,943.66. Plaintiff would respectfully request entry of a default against the defendant for a default judgment that the defendants would be required to pay that amount or move out on or before September 18th, 2023, or the writ may issue on or after September 18th, 2023.
Judgment to the plaintiff by default for possession redemption amount is in that amount requested with the writ issue 10 days. Court calls the case of Beal Properties versus Delgina Little.
Yes, Your Honor. Clifton Hitchcock, Swiss Stack.
I feel so bad for Jasmine Billings and Rita Palmer, actually. They're like, okay, we're watching everybody else's case, but they at least are learning something as it goes on. To what extent, I don't know, because it's moving quite quickly.
Levine on behalf of the plaintiff.
They're not here. They have not checked in. You may proceed.
Your Honor, there's currently rent to retain possession in the amount of $4,738,
Woo.
cost in the amount of $162, for a total amount due and owing in the amount of $4,900. Plaintiff respectfully requests entry of a default against the defendant by this court, by which a default judgment.
I'm telling you, when the defendants or the tenants don't show up, you get a default judgment, and that means nothing is defensible. You can't say, oh, the property has not been habitable. This money's been held for that reason. You can't say that we've made payments. You can't represent anything on the defense. So now you get a default judgment, and now this is almost $5,000 going against them in judgment, and trying to rent out another property with a $5,000 judgment against you is going to be really hard. You're most likely going to be looking at a week to week. And we learned in one of our other videos that 2 weeks nearly pay double the amount of a month to month in certain circumstances. So you're really being price gouged on a weekly rental compared to a monthly rental. And, then that, of course, a monthly rental typically is higher than a lease rental unless you came out of a lease and then you're going into a month to month and they just carry on the same amount. But anyway, nonetheless, it's not prudent towards your financial concerns to not show up and defend yourself, because good God, $5,000 is a lot of money to owe in Michigan for rent.
To be presented, providing that if defendant does not pay that amount or move out on or before September 18th, 2023, that the
10
writ may issue.
days.
Judgment to the plaintiff by default for possession redemption amount is in the amount requested. Writ issue in 10 days. Court does call the case of Beal Properties versus Rita Palmer.
How long have they? Oh, Rita's
Your Honor,
up.
Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff.
Ms. Palmer, you're at our access point. Can you unmute yourself?
Oh, poor Miss Palmer. She's like, they're talking to me. They're talking to me. There's nothing worse when you're trying to unmute. And
Yeah,
you,
can you hold down the, if you hold down the space bar, that will do it, ma'am.
not always. That
Can you
usually
hear me?
is.
You got it.
Okay. Hi,
Okay. What's your name, ma'am?
Lena Palmer.
All right, this is a termination of tenancy case, counsel.
Yes, Your Honor, it is.
Okay.
And Ms. Palmer, what do you have to say to the termination?
I need at least 2 to 30 to like 3 weeks because my other half, he died. I was living there taking care of him and he died. So I'm having hard times right now. My apartment won't be ready until about 3 weeks, like the 1st of the month. And
The 1st of October?
yes.
Okay, but you're not disputing the termination,
No,
correct?
I'm not. No.
All right. So here's what I'm going to do, counsel. I'm going to grant a judgment for possession, finding no tribal issue after a hearing. What I will do, and ma'am, my condolences on your loss.
Thank you.
You need, so your new place is going to be ready the 1st, you
Yes.
think, or?
Yes.
Okay. So what I'm going to do is it'll be a writ the 30th of September.
Okay. Deal.
Okay.
Okay,
Ma'am.
then how long do you have after that?
Why not a
Well,
COD?
then you got to get yourself, that's when they can file to have the sheriff come.
Okay, so the
To put you
29th,
out.
the
So
30th.
I'm giving you, instead of just to the 18th, I'm trying to give you your date so you can get yourself moved. So I'm giving it to the end of the month
Okay,
for you to
thank
get that done.
Thank you very much.
You're welcome, ma'am.
Have a
All
good
right,
day. Bye-bye.
you do the same.
So the question I have is why not just enter in a COD, condition for dismissal versus the judgment? But that's because, well, it's because of what they filed against her, which is termination.
Courthouse case of Beal Properties versus Damian Lovelace.
Oh,
Your Honor,
lovely.
Clifton Hitchcock with Stack Levine on behalf of the plaintiff.
Lovelace, where you go? Hey,
Mr.
Damien.
Lovelace?
Love
Good
it.
morning, Your Honor.
Okay, so what's the movie with Lovelace in it? There's a movie. Oh my gosh, it's a kids movie too. I can't remember the name of it.
Good morning, sir. All right. Last time we were here, we had some issues regarding repairs. And I
Yes.
think- Okay, where are we on that?
Well, they've made repairs, but my sink is still clogged up. Section 8 is gonna be doing a inspection on the 29th. And then therefore, I mean, honestly, they're gonna be paying the whole amount, but they're not paying the whole amount because repairs wasn't done.
Okay, so Section 8 is coming in to do as I
Another
recall, the
inspection,
Section
like
8
the
stop
third-
payment.
Yeah, it's like the third.
They have to
or
get the
fourth-
amount, they just have to get the repairs done.
Yes, and then they're gonna take care of the rest of the amount.
Got it.
I paid the 187 like we talked about last court.
You did what now?
I did pay the 187 from
Right.
the last court date we had, which was what I owed. I mean, I'm hoping Section 8 doesn't put on more late fees. I mean, honestly, the court cost should be waived because this is a thing that, Section 8 and Beal Properties had between them. I'm here because I didn't pay. Well, obviously, Section 8 was supposed to pay, but Section 8 didn't because the repairs weren't done.
Okay, here's what I'm gonna,
I agree with his reasoning. I don't know how far he's going to get, but I like his thinking. He's saying this is not my fault because one of the things you want to remember. So there are certain entities that will come in and they'll do like rescue funding to like rescue from your arrears or, in certain disasters, they'll give you funds that you can put towards your rent. And that's one thing. But Section 8 is specifically a contract. It's like a third party contract, right? The landlord has to agree to accept Section 8. A part of accepting Section 8 is accepting their particular rules and regulations for how the housing should be to code and under what condition. Because truthfully, though you have a tenant that's in and they may have a particular portion that's due that they pay themselves, mostly, if not all, will come from Section 8. So consequently, Section 8 is going to ensure that what they're paying for is, in their eyes, reasonable and habitable. So something like a clogged sink doesn't sound so abnormal as far as habitability. It doesn't affect your health and, doesn't prevent you from living there. However, Section 8 is like, no. And I say that kind of lightly because, it can get out of hand if you're having mildew now being created and other spores and things are being created. But typically, if you do have a clogged sink, you have the reasonable thought process to take the water, dump it down the toilet, or to throw it out, depending on what's in the water. If it's something that can't be put into the toilet, you throw it outside. Or wherever, wherever it's a reasonable discharge until you can get the sink fixed. Things I have also seen Section 8 deny payment on is like if there wasn't a light bulb. Like you got to get a changed light because what the tenant will say is, my light in the hallway doesn't work. And then no one's looking to see if you just need to change the light bulb, right? And so Section 8 will stop payment and they want you to send out a contractor, not just any contractor, but a licensed contractor to confirm that it's not electrical issue, but that it's just the light bulb. So there are some landlords who just won't accept Section 8 because though it is ensuring that the tenant is living in habitable conditions, there are times when it's like, really, let's at least try the light bulb. Does that work before we have to send out a contractor? Because you're going to have to pay the contractor to come on site. And then they have to fill out certain paperwork. Some contractors will charge you $10 for the paperwork too, not just coming on site to fix something, because if they've got to now attest to it in writing, they get another fee for it. So I've seen that happen. But I agree with his reasoning. He's like, it's not my fault. Section 8 doesn't want to pay for it because they find that it's a breach of their contract habitability. And you have to cure it with them. And Section 8 is going to come out when they're available. So they're not available tomorrow or the next day. This guy is saying they're coming out on the 29th, the end of the month.
I mean, I paid over $1,000.
Okay. When your inspection time is on the 29th?
I don't know what exact time. But,
okay, so
because
here's
it's
what we'll
in between time.
Okay. Hold on a second. What's his time on the 29th?
Sure. Thank you.
His time would be 2 p.m.
Okay, so maybe we'll get the inspection before then. What I'm going to do is I'm going to adjourn this because it's really just Section 8 payments. You made your payment in, so the plaintiff won't be at a loss. I'm going to adjourn this to September 29th, 2023 at 2 p.m.
So court costs are not getting waived. But I like that the argument is really good. But the court's saying, no, we're here, we're working this case, so we will get paid.
All right. So,
okay.
And counsel, if you could just note that there's still repairs that need to be done. So hopefully we can get this unit passed and then everybody can get themselves caught up.
On Bill's behalf, they did repairs. I still have a clogged up sink, and that's about it. They made good work with it.
Okay. Will do.
All right. Thank you.
Okay, Your Honor, you have a good afternoon.
You do the same, sir.
Thank
Park
you.
at Sage West Circle versus Micaiah Williams.
Yes, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of the plaintiff.
This tenant is not checked in.
You may proceed. They have not checked in.
Okay, Your Honor. We have rent to retain possession in the amount of $3,659.11. Cost in the amount of $168 for a total amount due and owing in the amount of $3,827.11. Plaintiff respectfully requests entry of a default against the defendant and default judgment requiring the plaintiff to either pay that amount or move out on or before September 18th, 2023, or the writ may issue on or after September 18th, 2023, Your Honor.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days.
Thank you.
West Ridge Mobile Home Park versus Carmen Terraza.
Okay.
And
Good morning.
Javier Buda.
Good morning, Your Honor. We confirmed this morning receipt of payment from property management, and so that's a dismissal that's been submitted to the court.
And I don't think we have it yet, but this case is dismissed. That's without prejudice.
Okay.
Court does call the case of West Ridge Mobile Home Park versus Jacob Vernier.
Okay, real quick. He's saying dismissed without prejudice. So for those who don't know, without prejudice means that if the plaintiff needs to, they can bring this case back to the court and refile. With prejudice means the plaintiff cannot bring this case back and refile. So that's the difference between with or without prejudice.
Yes, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of plaintiff Westridge Mobile Home Park.
I have somebody here, I think.
Here.
Hello, what's your name?
Laura Vernier. Jacob's my husband.
Okay. And
But you're not on
counsel,
the,
how much is owing?
Your Honor, rent to retain possession is in the amount of $1,340.37, cost of $170 for a total amount of $1,510.37.
Ma'am, what do you have to say about that? Although you're not the one on the case, if that's your husband, I'll hear from you.
So he just started work this past Tuesday because he's been out of work for like a month and a half. And so he's gonna start getting regular paychecks as of next Friday. And I also get my student loans back from my school on the 21st, I think it was. And so I was wondering if I could make a payment each Friday for the next 3 weeks. And then I will also apply my entire student loan to the balance as well. I did file for, it's my half, it's MIHAF. And I have not heard anything back from them, but Hawk, as of my husband's job right now, he makes $200 too much.
okay, so Hawk doesn't, okay, so she's looking into remedies, so that's great. Student loans come back in September. That must be half of what that's student loans. So what happens is you go to school, and whether you get a student loan or a grant or whatever, the overage is paid out to the individual. And that particular refund, student loan refund or tuition refund, comes in 2 payments. I guess the first half is September, the other half is November, or something like that. Anyway, so that's what she's gonna do that. I'm concerned about whatever. I guess it's kind of fast and loose and it's okay. But I would take issue with the fact that they didn't swear her in to tell the truth and the whole truth and nothing but the truth. So we got, they didn't do that. She's coming in as a witness and not a party. So they definitely need to swear her in. And she's making representations on the party's behalf as to when that party can make the payment. But he's waiving the issue for that because they're married, so that's atypical. But usually when a judgment is against one party versus the other, the judge only wants to hear for which, the lease. If the lease is in one party's name and not the other, the judge typically only wants to hear from that person, unless the wife, the spouse, whatever is called as a witness. This is a little different to have her attest to when they can make these payments, especially since she's not listed. So is it binding? I guess so, because she's before court. That's an interesting legal argument. Like, is her representation binding? So what happens if she falters or he falters on one of the Fridays and doesn't make the Friday payment over the next 3 weeks? Can he come in and say, well, Your Honor, I didn't represent that I get paid once a week. I only get paid every 2 weeks. Or, I didn't want to start this first check. I was saying the last 2 weeks, and she misrepresented to the court and misunderstood my instruction. She's not an agent for him because she's not an attorney, not licensed, so she can't represent him in that factor. So interesting, if you would be able to argue, let me know. If you are a lawyer or you have some legal mindset and you have, or even opinion, just go ahead in the comment section and let me know what you think. Would that legal argument be an issue if he comes back to court within a week or two and says, I didn't make the first payment on this Friday because this is my very first check. I wasn't, I just got back into work after this last month and a half. And my wife misrepresented to the court when I can make the first payment. The first payment I cannot make until the next Friday. What if he comes back and says whatever, but he wants to renegotiate terms and figures that her terms are not viable for his ability to pay. Would that be an issue since she's not a party to the case because she's not on the lease? And, then is there enough issue that she's making these representations to the court, but she's not under oath and she's not an attorney? Will we have issues there? The other thing is when we're living paycheck to paycheck, this is so easily this can occur so easily. It can be such a simple short time frame, a month and a half, and you're already going into, I don't know, it's got to be at least 2 months behind before you can get this far into court, but whatever. you're in a place where you're not able to make these payments for rent. And consequently, you're up before court fighting eviction. Living paycheck to paycheck is so hard. It's so hard because it's real easy to fall enormously behind. You can't get sick. You can't take days off. You can't switch jobs. So, hats off to everyone who is living paycheck to paycheck. Godspeed to you.
Okay, so
But I really, really do want to get this paid off and I want to.
I understand. Here's what we'll do. Council, the total amount was $1,510.37. Is that right?
Yes, Your Honor, correct.
All right.
Not bad.
So what I'm going to do is I'm going to find no tribal issue after a hearing. I'm going to issue a judgment in that amount of $1,510.37. And what I will do, ma'am, is you're expecting your student loan on the 21st, correct?
Correct. And
Hold
I know,
on, hold on.
please.
Oh. Here's what I'm going to do. No rent till the 25th. Okay. So you'll have until after the 22nd to get that paid. Okay.
Okay, thank you.
You're welcome.
Okay, so judge kind of just fixed it all in one soup. Judge just love judges. They're so smart. He didn't even entertain this payment plan that she was coming up. He's like, look, do what you got to do. Get the money in Thursday, Friday, Saturday, Sunday, whatever. And you have until the 20th. So I love it. But I still want to know what you think. So put your answer in the comments. I wanted to hear from you.
Have a good one.
You do the same. Court calls the case, Westridge Mobile Home Park versus Brittany Williamson.
Clifton Hitchcock, Swiss Stack Levine on behalf of plaintiff, Your Honor.
This tenant is not checked.
Tenant has not checked in. You may proceed.
Your Honor, there's currently rent to retain possession in the amount of $698.52, costs in the amount of $170 for a total amount of $868.52. Plaintiff respectfully requests that this court enter a default against the defendant in default judgment by which the defendant must pay that amount in full or move out on or before September 18th, 2023, or the writ may issue on or after September 18th, 2023.
Judgment to the plaintiff, that's by default for possession redemption amount is in the amount requested, writ issue in 10 days. All right, I think that's it, counsel. You have.
So we're talking less than $1,000, and this person can be evicted from their home. And for us in Southern California, we're like, oh, we wish that was our mortgage. No, that's the insurance, right? That's the insurance on our car, $1,000. So my heart goes out to her. Hopefully she'll be able to, tenant will be able to pay it. Just to think about that. Think about that for yourself. Less than $1,000, which could be astronomical for certain parts of the country, but less than $1,000 owed can have you evicted out on the street and homelessness. We can be homeless for such small amounts of money. Does not take much. So, hopefully that won't be her circumstance and she'll be able to pay it, but we don't know. I don't know.
Have a great weekend.
Yes, Your Honor. You too. Thank you, Your Honor.
All right, so Hitchcock is out of the building. Okay, so I want to know. I want to know. I got to find out. Is he related to Alfred Hitchcock? Alfred Hitchcock. First. He doesn't come up as siblings, but he probably would be a great grandchild. Oh my gosh, Alfred Hitchcock died right before I was born. He did have a child. So I didn't even. He had a daughter, Patricia Alma Hitchcock O'Connell, and she just passed away in 2021. English actress and producer. Oh, excellent. Let me see. Children. So he probably, unless he's like a cousin or something like that, really do not see he's not a child or grandchild of Hitchcock. Okay. So let's see, what was his name? Clifford or Clifton? I didn't write his name down. Don't be mad. I want to know. I'm so Clifton. I'm so intrigued. Okay. I am intrigued. Maybe you were not. But I am. Is Clifton Hitchcock related to Alfred? So there's no immediate relation noted, at least not with Google, but who knows? It could be like the great cousin, great nephew of Hitchcock. He did have a sibling, so they may have been related that way. I don't know. And then Alfred Hitchcock's middle name is Joseph. Excellent. I just love it. Okay. Learning all the things about the wrong thing, right? We didn't come here for that. But there we go. That's what makes court fun. You come for one thing and you might learn something else, right? All right, so today was fun and eventful. We got a lot of dismissals, or at least a lot of default judgments. And what do we learn from that? Tenants come to court. That's what we learned. Come to court and speak your piece. Don't let it build up. Try to be proactive. This goes for landlords as well. Be proactive. I am very concerned about the mildew and mold situation that the landlord is allowing to fester. Like, you need to put in a window, do something. I don't know, call Tyrone. Erica Badu said, call Tyrone. Somebody, you need to call somebody to come out and really assess that situation and see what a solution is on a long-term basis. Financially, it may be cumbersome because that is typically what happens with landlords. It gets to a point where the upkeep of the property does not really align with the rents that are collected, and consequently, it becomes hard for them to make those adjustments. But tricks of the trade. See where you can use insurance. Make a claim on your insurance if that's possible. See if funds are available there. They will have the contract and make fixes if it is. The other thing is, see if you qualify for an equity line of credit. Pull equity line out and have a reputable contractor, licensed contractor, come in and make the fixes. And the reason why I make that distinction is that you make sure that they're licensed and reputable is because you don't want a contractor who has a license that's not reputable, or one who doesn't even have a license, to come out and make these changes and turn around and give you a bigger problem down the road, or do some small fix and cost you, some money that you can't go back, right? You want it to be an actual fix that really does well for the property on a long-term basis. So those are suggestions, my little bitty opinion. Do as you see fit. Hopefully some of that will jog your creativity and help you determine what you can do for yourself. But overall, we have learned to not disappear, and make sure that you come on out. Come on out, be proactive, speak with your landlord beforehand if you can about making payments, and see about those payment plans, whatever the case. See if you can get a stipulation for judgment, or what I would ask is for a conditional dismissal, because that looks better than the judgment on your record. That young lady from one of our cases, so maybe not this maybe the last video. I think her last name was Tucker. One of the young ladies was very expressive, like, I on my record. Good. I'm glad you're thinking about that, because a judgment on your record does make it difficult for trying to get into a new space. So if you can avoid it, please do try to negotiate a conditional dismissal so that you get it dismissed versus judged upon. All right. I'm Rick Armstrong, your real estate agent and advocate. So don't forget to like, share, and subscribe. As always, we're learning things here. That's what we are doing. So maybe you've done this and said, Lyric, I know all this. We've talked about this. I am well versed in it. Great. Share the video with someone else. Let them learn too. Share it on your platforms. Like I said in the last video, quite honestly, your friends and your family, well, maybe your family, but your friends and acquaintances, they're atypically not telling you that they have mental issues and problems with their landlord and issues with funds and not able to pay rent unless they're asking you for the money. So what you can do to avoid them asking you for the money is just go right ahead and put the video up and share it on your platforms on social media and they can watch. We've learned of Hawk being a good resource, or a potential resource. And then there was an Arbor something, or Harbor housing that also was another resource for financial relief relative to rental assistance. So this could be helpful for them. All right. Once again, we're going to lose the agent. Have a good one. I hope you're having a fun time enjoying your weekend, and I'll see you later.